Good day, ladies and gentlemen. Joy Stephen from the Polinsys Studios, and here is another case law for the Student Herald. KN versus Canada. Now, case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog, reportersreport.com, as a PDF document. Now, this is an immigration case law. Inadmissible and removable, the different topics are inadmissible and removable classes. Terrorism, ministerial discretion. Refugee was a Pakistani national who had been member of Mohajir Quami Movement, MQM, or one of its successors from 1986 to 1997. MQM had engaged in acts of terrorism. Refugee came to Canada and was granted refugee status in 1999. Refugee was found inadmissible under S34 1F of Immigration and Refugee Protection Act of Canada due to having been member of MQM and one of its successors. Refugee unsuccessfully applied to Minister of Public Safety and Emergency Preparedness for ministerial relief under S34 2 of Act. Minister had followed recommendations issued by CBSA. Refugee brought applications for judicial review. Application was again dismissed. Fact that Minister referred to discretionary ministerial relief as exceptional did not amount to reviewable error. Word exceptional had to be read in its immediate context as well as in context of decision as a whole. Minister intended to distinguish ministerial relief from other forms of relief and to clarify that ministerial relief had its own purpose and criteria. Minister had in fact followed applicable Supreme Court of Canada SSC authority, and there was no indication that Minister imported some kind of exceptional test to deal with relevant factors. Decision indicated Minister assessed and weighed various factors in accordance with SCC authority and reached conclusion that was not outside range of possible acceptable outcomes. Minister had not been required to identify specific acts of terrorism committed by MQM. Minister had carefully examined refugees' assertion that he was unaware of MQM's act of terrorism. Fact that MQM had not been listed as terrorist organization is irrelevant to findings that it had engaged in acts of terrorism. Fact that refugee had been granted refugee status did not preclude finding him to be inadmissible. Minister had not been obliged to wait for outcome of appeal in another case. Very, very interesting case. KN versus Canada. It's dated December the 11th, 2015 from the Federal Court. Thank you.